council as to any suggestions, corrections, or objections. And these were drafted over the course of the trial, so there's some that may no longer be relevant, and then there's some that we may need to add. So for the record, 101.05 is function of the jury, 101.10 is burden of proof and reasonable doubt, 101.15 is credibility of witness, 101.20 is weight of the evidence, 104.94 is testimony of expert witnesses, 104.50 is photographs, diagrams, etc. as illustrative exhibits, 104.05 is circumstantial evidence, 104.15 is evidence of similar acts or crimes, 104.36 is flight in first-degree murder cases, the 101.30 needs to come out. Then the next one is the substantive instructions on first-degree murder where a deadly weapon is used, covering lesser included offenses, as well as a self-defense instruction. The only lesser included offense that I would see not relevant in this case is the involuntary manslaughter offense, so that the charge would be for first-degree murder, second-degree murder, voluntary manslaughter, or not guilty. And then, like I say, incorporating the self-defense instruction. I did want to look at the second element of the first-degree murder offense, which is the proximate cause. I had included just a little research in there, just as a bookmark mostly, but we'll go back and talk about whether the instruction as it is and the pattern instruction is adequate. The next substantive, well, the next instruction is 104.10 is the motive instruction. And then I could not find a larceny of a chose of action instruction, so I used 216.11a, which is felonious larceny of a firearm, and replaced firearm with a chose of action and then defined what a chose of action is. And I repeated that instruction twice, one for the $400 money order and second time for the $300 money order. And then finally, 101.35 are the concluding instructions. So what I would ask first, Ms. Franks, based on your initial review, are there any instructions or any comments, corrections, or objections that you have with respect to what you see before you?
No, Your Honor, as to what I see before me is fine. I would ask about 105.35 and 105.40, 105.20.
All right, if you'll give me
105.20, impeachment of corroboration by prior statement. 105.35 and 105.40, which is proof of crime for impeachment purposes of defendant and those other than the defendant.
All right. All right, Mr. Meyer, do you have any, upon your initial examination of the instructions, do you have any objections, corrections, or suggestions?
I don't, Your Honor, and I agree with her on those. I don't see anything wrong with those 105, 20, 35, and 40.
All right, and Ms. Franks, let me hear from you with respect to the second element, the proximate cause element. The way the pattern instruction reads is a proximate cause is a real cause, a cause without which the victim's death would not have occurred. There's some case law, particularly one case that deals with negligent treatment. That theory was maybe alluded to but not developed, particularly in the evidence. So do you feel, Ms. Franks, that further elaboration on the proximate cause instruction needs to be provided?
And I like what you've added in here because it was alluded to by the defense and enough that they can use it in an argument. So I would ask that that language remain.
All right. I may rework this language so that it's, so that it's a little bit more consistent with the other language. But that was a couple cases that I had citations too when I was looking at this issue earlier. Mr. Meyer, do you have any thoughts on that particular issue?
No, I mean, obviously it was alluded to and certainly may come up. So yeah, I'm fine kind of with the additions you've got, as long as, again, they get worded consistently, because unfortunately jury instructions are never worded quite normally.
All right. Okay, then I'll massage those a little bit and take out the case citations and make that a little bit more consistent with the other language. Do you have another issue you need to bring to my attention?
No, Your Honor. She was just asking if your practice is normally to let the jury take it back, or if you wait until they ask.
Yes. Well, I do it several different ways. Oftentimes, I give the jury a printed copy as I read them and ask them just simply to follow along, and I'm happy to do that. In this case, I always, in my discretion, allow jurors, if they ask for jury instructions, to provide printed sets to them as they begin their deliberation, and I usually inform them that they can make that request. So it is my preference that they have the written instructions available to them. In any objection, what I prefer to do in this case, quite frankly, is to provide the instructions as I read them, so they would have a printed copy in their hands that they could follow along and take notes if they wish, because they'll be able to keep those copies during deliberations. Any objection to that procedure?
No, Your Honor.
No, Your Honor.
All right. Okay, then hearing no further, I will add those three instructions that you suggested, 105.20, 105.35, and 105.40. With respect to the verdict sheet, the clerk has prepared one that's consistent with the instructions that we've just reviewed. In a few moments we'll go on recess. You can just take a chance to review that, so we can put on the record tomorrow that you've had a chance to review it. I'm going to work on finalizing these instructions, and I'll be glad to email them to you this evening. And what I'd like to do is just very briefly in the morning go back on the record with the charge conference and just ensure that everybody has had an ample time to review it and note any objections, corrections, or suggestions that you might have as to these instructions. But I would hope that that wouldn't take long. Hopefully we've addressed all the issues that we need to within this initial charge conference. All right, now as far as the order of the closing arguments, Ms. Franks, do you wish to make an opening? You'll have the final argument. Do you wish to make an opening and a closing?
No, Your Honor, just a closing.
All right, so Mr. Meyer, you'll have the first argument, and Ms. Franks, you'll have the final argument. Any idea on the time? I don't know what your practice is. I'm not imposing a limit, but I'm just for planning purposes.
Honestly, every prediction I've made about time in this case has been so far off. I'm not one for real lengthy ones, but at this stage I can't really predict that accurate, but not that long.
Okay, all right. Ms. Franks, do you envision more than hour and a half, 2 hours? I don't want to limit you, but
I mean, the longest I've ever gone is an hour and 20 minutes.
Okay.
So I don't think it'd be over that.
all right, that's fine. Very good. Then we'll start at 9:30 tomorrow morning, and I believe that's all we have for today. Thank you.
Oh, should we just one out there?
Yeah, just making the bell.
I can't believe he's sitting this out.